An interesting new case out of New York highlights the risks of adopting a business name that someone else believes infringes their trademark rights. The case is the Museum of Modern Art against MOMACHA IP LLC and MOMACHA OP LLC. Earlier this year, the world-famous Museum of Modern Art, which is widely known as MoMA, brought suit against a cafe called MOMACHA, which had recently opened in the Lower East Side of Manhattan. Last week, the judge in the case issued a preliminary injunction, barring MOMACHA from continuing to use the MOMACHA name, logo, and the MOMACHA.com URL until the legal proceedings are concluded. MoMA argued that the cafe's name referenced MoMA and cha, a word which means tea, while MOMACHA claimed the name simply meant more matcha, with mo standing for the word more and matcha being a reference to the popular Japanese green tea known as matcha tea. In deciding to issue the preliminary injunction, the judge sided with the museum on virtually all points. The net result was the cafe was forced to change its name, logo, and font and rebrand under the name MOMACHA. The lawsuit was reported in the New York Times and other media channels. One of the many interesting aspects of the case involved the cafe's attempt to distance itself from MoMA by openly disclaiming any affiliation with MoMA on its door, its receipts, its website, its social media pages, and a sign inside its store stating it does not have any affiliation with the Museum of Modern Art or any museum. The court was unpersuaded and concluded that disclaimers are frequently not effective, especially those that employ brief negator words such as no or not, as in MOMACHA's case, and noted consumers often make purchase decisions quickly and may not see the disclaimer, or worse, be even more confused. Another interesting aspect of the case involved the existence of actual confusion amongst consumers. Specifically, the court took note of social media posts by consumers who believed that MOMACHA's beverages were affiliated with the museum. MOMACHA argued the court should not issue the preliminary injunction because it would cause MOMACHA economic hardship to change its name and logo on its website, promotional materials, cafe items, and social media platforms pending the outcome of the litigation. But the court sided with the museum on this point because the costs were quantifiable in contrast to the unquantifiable harm to the museum's brand. This case provides a good reminder to those who are launching a business or a product under a new name that the stakes can be fairly high. To avoid the significant cost of litigation and rebranding after your launch, it's best to get a well-founded legal opinion from Trademark Counsel whether a new name may conflict with anyone else's registered trademark. The old Benjamin Franklin adage applies, an ounce of prevention is worth a pound of cure. A link to the court's opinion and injunction is provided with this post. Thanks for watching and have a great day.